Tonight, Southland law enforcement agencies are making some changes in the way they search criminal suspects.
The Supreme Court, in a unanimous decision, set limits on how far police can go in searching suspects' cell phones.
KCAL-9 political reporter Dave Bryan has a story live tonight from LA County Sheriff's headquarters in Monterey Park. Dave.
That's right, Lena and Sylvia. Officials here are telling me that in many cases, the Sheriff's Department was already obtaining search warrants before searching a suspect's cell phone. They were already doing that in many cases, I was told. In some cases, however, they were not. And now they say that will change as a result of the Supreme Court's ruling. The Supreme Court ruling will be felt most directly on the front lines of crime fighting. When a suspect is arrested, for example, LA County Sheriff's deputies and other law enforcement officers can no longer routinely search the suspect's cell phone without a warrant, except in some emergency situations like a bombing.
It has a significant impact. Most of our deputies are following what the U.S. Supreme Court has announced today anyway, but there's a certain percentage that did see this as a significant change.
On a court that's been deeply divided on most major cases involving conflicting rights, the justices were unanimous this time. Chief Justice John Roberts wrote this about cell phones: such a pervasive and insistent part of daily life that the proverbial visitor from Mars might conclude they were an important feature of human anatomy. Privacy advocates say searching someone's cell phone is different than searching their wallet or coat pockets.
Because what people carry around in their cell phones now are not just their money or credit cards or just their phone, it's their entire life. Their medical records, their bank records, their photo albums.
But the International Association of Chiefs of Police called the ruling disappointing, charging that it will undoubtedly impact law enforcement's ability to investigate and combat crime. I asked Commander Parker about that. Is this, in your opinion, a setback for law enforcement not being able to automatically go through the cell phone?
I think yes and no. Obviously, we would like to have as much leeway as possible to help protect the public. We certainly respect the court's decision to better define exactly what the law allows.
Privacy advocates agree that changes will impact law enforcement practices, but they say it will be in a positive way for fairness, justice, and protection from unwarranted search and seizure.
Well, it's been standard police procedure when they arrest someone and they pat them down, they take everything that's on them, including their phone, and they search that for evidence of crime. Now that procedure has to change. The police still can secure your phone, but they need some independent reason to search it. They can't just go on a fishing expedition willy-nilly.
Now, at the LAPD, officials there say that they have obtained some crucial information in many cases from searching suspects' cell phones. But now they say their policy will also change to comply with the Supreme Court ruling. Their concern is that during the time that a search warrant is being obtained, the suspects will delete that crucial information from their cell phones. We're live in Monterey Park. Dave Bryan, KCAL-9 News.